You. Good afternoon, everyone. We're here with Disability Rights California. My name is Yulahlia Hernandez. I'm an attorney and senior clients' rights advocate with a unit called the Office of Clients' Rights Advocacy within Disability Rights.
And my name is Blaz Gutierrez. I'm the managing attorney of the Fair Hearing Project and Youth Practice Group, housed within the Legal Advocacy Unit. I'll explain some of that in just a moment for you.
So Disability Rights California, many of you may be familiar with our agency. We're a large legal nonprofit that gets federal and state funding to provide advocacy services for people with disabilities throughout the state of California. And we're also the designated protection and advocacy agency within our state. And the Office of Clients' Rights Advocacy, which is the office that I'm a part of, we are under the umbrella of Disability Rights California. We get state funding from the Department of Developmental Services to provide advocacy for regional center consumers, and we'll talk about the regional center at length in the rest of the training, to provide advocacy for regional center clients. And there are two a client's rights advocate and generally an assistant client's rights advocate for each regional center that clients can contact if they have legal questions, generally surrounding public benefits, but we also do much more than that.
And the Fair Hearing Project represents a more recent innovation within the organization, somewhat of a response to a variety of concerns that were raised both by the community and within the organization to try to overcome primarily language access related barriers. There is a number of data that shows that Spanish-speaking individuals are not receiving the same level of services through the regional centers as others. And so our team was created to help provide direct legal representation at administrative hearings, essentially appeals, again, which we'll be talking about at length in this presentation. The second half of this presentation will be related to dispute resolutions. And we are here to help ensure that we are extending our advocacy efforts strategically to people with intellectual and developmental disabilities who identify also as Latino or Latinx or Latine. Next slide, please.
So the regional centers were created in the 1960s through the Lanterman Act, starting at Welfare and Institutions Code 4500. And the regional center system was created in response to wanting people with developmental disabilities to have services in the community instead of in institutions. Generally, the default was for people to be institutionalized before the Lanterman Act if they had developmental disabilities or other disabilities. And a group of self-advocates and parents really lobbied hard to get the Lanterman Act and all the funding with it to create supports that we're going to talk about in the community. And it's intended to give folks services and supports to allow people to have, as they say in the law, more normal and independent lives, and to combat the previous inhumane and unjust and terrible conditions that a lot of the institutions had for people. The other piece of the regional center is they also provide early intervention, early start services to youngsters under 3, from 0 to 3, ending at their 3rd birthday. And that is generally under the Department of Education. So there's a different criteria for eligibility, which we'll talk about, but there's 2 parts to the regional center system. Next slide.
It may be that you have never heard of the regional centers. It may be that you have never heard of the Department of Developmental Services. And that, I think, only goes to show that the stigma around persons with developmental disabilities persists quite significantly to this day, despite the significant changes that have occurred. Our default, as Yulahlia just mentioned, was essentially to institutionalize persons. And through significant advocacy efforts, we now have a completely different societal attitude where the default position is to keep people at home in the communities of their choice, and to live free and independent lives without having to be submitted to an institution. As you can see here, there are approximately 500,000 quote unquote consumers. Those are the persons who are receiving services through the regional center, who obtain services all around the state of California. This is not money that is only being processed in and around Sacramento. This is money, approximately $10 billion worth of expenditures that are being spent by in-home service providers, by people who are spending time developing one-on-one skills with consumers, access to gym memberships and community outings. It really is, especially for those of you who are here at this presentation today, motivated by poverty law issues. This is sort of that call to attention. This is what should be hopefully getting you interested in learning more about this, because it really is a very significant outlay of cash that can be destined for our local communities around the state of California. That roughly breaks down, as you can see on your screen, to about $30,000 in expenditures per each consumer. However, as I mentioned earlier, that distribution can vary quite considerably, with a large number of people receiving quite literally $0 worth of services, and others who are receiving many hundreds of thousands of dollars worth of services in the course of just 1 year. And when we share this presentation, you'll see links to some data that's available. The first link is to data that's maintained by the Department of Developmental Services. And the second link here is to a report that was drafted by our colleagues in the Intellectual and Developmental Disabilities Practice Group here at Disability Rights California, that attempts to understand some of the different root causes of those discrepancies, be it race, ethnicity, language, or other type of factor that might be skewing against you in your search for services here.
We'll switch to discussing early start a little bit on this slide, and we added a link to a CDC milestone tracker, the California, what does CDC stand for?
Center for Disease Control and Prevention.
Thank you, Blaz.
Yeah.
The milestone trackers, so just folks have an idea of, it's a good tool to use, especially any, healthcare providers or even families, to see, where their children should be at. And if they're not quite there, they might be eligible for early start, early intervention services through the regional center. So we just had a quick chart, that there has to be a developmental delay in just one of these 5 areas: cognitive development, physical and motor development, communication, social, emotional, and adaptive development. There's also children who are at risk, such as children whose parents are regional center services, or who have been involved in, maybe CPS matters, who are at risk of having a substantial disability, can also get some early start services. So we just like to point this out. It's a different eligibility criteria than lifelong Lanterman Act regional center services, but it's important, and there are a lot of services available to the little ones, under 3, under this. So oftentimes folks, I would say probably, I don't know, the majority of folks who do get early start services won't necessarily be part of the regional center for life, but they'll get services, that would hopefully can benefit them for life with intensive therapies and services. Let me go to the next slide. So this is focusing on regional center Lanterman Act eligibility. And generally, this is looked at after someone is 3 years old, though there are some kids under 3 who might clearly be eligible, but generally it's looked at after 3 years old. And it's kind of a two-prong process. The person has to have one of these eligible conditions, so autism, epilepsy, cerebral palsy, intellectual disability, or, and there's something that's kind of as referred to as the 5th category, a condition that's similar to or requires treatment similar to an intellectual disability. And sometimes we see this, especially when IQ testing was really tied, I think, more to a numbers than adaptive skills. If somebody was just a little bit above an IQ test to fall under the intellectual disability category, but needed similar treatment and had a condition or had a condition similar to someone with an intellectual disability, this is what that category was created for, the 5th category. Not everybody who has one of these conditions is going to be eligible, because there's the second prong that we'll be talking about in the next slide. But this is the first step to have one of these diagnoses. The condition has to originate before the age of 18. So you have to be able to show with evidence that they had this condition before the age of 18. I know sometimes some people with some traumatic brain injuries might fall into the 5th category, requiring treatment similar to someone with an intellectual disability. However, if the traumatic brain injury occurred after 18, they wouldn't qualify because it didn't originate before the age of 18. It has to be substantially disabling, and that's the second prong that we will talk about in more depth in the next slide. Has to be expected to last indefinitely, and it can't be solely physical, solely learning, or solely psychiatric. And so someone just can't have ADHD, an ADHD diagnosis without another diagnosis and be and fall underneath maybe the condition similar to an intellectual disability, or be eligible if it's solely psychiatric. They have to be a California resident, so living in California, but the regional centers don't look at immigration status for eligibility or to provide services. So we just want to be really clear about that. A person's immigration status doesn't matter as long as they're living in California and intend to stay living in California. In the materials, the final materials, there's a regional center eligibility memo that will attach to that walks through some of the eligibility, questions and provides more in-depth information. Yes, we could go into the next slide. So the second prong is that the disability, the diagnosis has to be a significant limitation in 3 or more of the following areas. And so this is really where the regional center really looks at, especially when, especially when maybe someone has some, maybe their grades are a little bit better and they're not suffering having as many school issues, so you don't kind of have that evidence. But the regional center is really going to look at this person's ability to care for themselves, how are their self-care? And sometimes it's a little bit more obvious when they're a little older. So maybe a 4-year-old, you can't really show that they are, really delayed in self-care, because a lot of 4-year-olds need a lot of support. But maybe at 8 or 9-year-old, an 8 or 9-year-old who still isn't able to go to the bathroom independently, who still, isn't able to maybe wash their hands or dress themselves, without a lot of prompting. That might be something to look at for self-care. And then there's receptive and expressive language. So they need to have delays in both areas, not just one. And so this is another area that sometimes the school, you could find evidence from the school district to show that they have a lot of speech therapy, and maybe that can show that they need receptive and expressive. They have receptive and expressive language delays. The ability of somebody to learn. So you could look at the school. You could also look at how the person, is learning things at home. And I had an example once of a mom talking about, taking their child to swimming lessons, and most of the kids only had to take the lesson the same, they would graduate to the next level within 2 or 3 swimming lessons. But, her child didn't graduate for 10. They had to have 10 swimming lessons to graduate. So it's really thinking about how the person's learning. Is their learning delayed compared to their peers? Mobility has to do with the ability to somebody to, whether they're using a wheelchair. Those are things that they look at with mobility. Self-direction is the person's ability to, excuse me, to get them to know to call a doctor if they're a little bit older, if they're not feeling well, to say that they need to take some aspirin, things that they need to do on their own. For self-direction, they don't they don't need reminders, they're taking initiative. And then for the older folks, excuse me, this air conditioning in here. For the older folks, it's the capacity for independent living. How's their house look? Are they able to to clean up after themselves and do dishes and have a safe living environment without a lot of help? And also economic self-sufficiency. Are they on SSI or can they learn how to do job skills? And then we could go to the next slide. So the first process in the application process with the regional center for regional center eligibility is to contact the regional center. And then the regional center determines if they need to do additional assessments. So sometimes it's really helpful to have school assessments or medical assessments that you can provide to the regional center to see, and they'll see whether or not they need additional assessments. For early start, the timelines are really tight. There are 45 days to complete the assessments. And for Lanterman, it's 120 days. To complete the assessment, or 60 days if it's an emergency. Unfortunately, the regional centers are taking a lot longer to do the assessments. We're hearing, 6 months from some regional centers, up to a year for others. And we haven't figured out a kind of a quick fix for this, but it's really following up with the regional centers and, knowing where they are in the process. The assessments are delayed because they just don't have a lot of psychologists, and they're having a lot of new eligibility intake.
I'll cover you. Maybe have the next slide, please. Okay. So assuming you are able to establish eligibility, and those of you who are familiar with the ADA may have seen some similarities between that eligibility criteria that Yulahlia showed and what you might be familiar with through the ADA. Here, clearly, we're talking about people with greater needs than just one condition that substantially impacts a major life condition. We're talking about people who have complex needs, oftentimes with overlapping diagnoses that impact their ability to live independently. Assuming you are able to get through that eligibility and show that you are entitled, and it is an entitlement, it's not a benefit, to these services, one of the first things that will happen is that you will get a letter introducing your new service coordinator to you. And the relationship between the service coordinator and the consumer is incredibly important. We're about to talk about, at the second part of this presentation, how to resolve disputes, but I think it's important to emphasize that each of the regional centers themselves are independent nonprofit organizations. They are mission driven. They receive contracts via the Department of Developmental Services. But there can be moments that, things don't work out the way that we would hope them to be. We do treat them, however, at the very least as good faith actors, considering that there is such an important relationship there. That service coordinator will be the guide for the consumer to help them develop what's called an individual program plan, the IPP. And if you have ever done any special education work, you might be familiar with the IEP, the Individualized Education Plan. And those of you who are familiar with the Department of Rehabilitation might be familiar with their planning process and documents as well. All of this has this recurring theme of individualization. Anything that is just sort of like generically applied to everyone simply won't meet my individualized needs. And so the IPP functions essentially as a contract, using that term loosely, between the consumer and the regional center. It lists all of the services and supports. It should be a document that lays out sort of what any individual's vision for themselves might be. So just think of, any type of, work plan or, personal coaching that you might have gone through and ask yourself that question, where do I see myself in 5 years? The IPP somewhat tries to get there. It tries to lay out a vision of who this person wants to be. Do they want to be someone who is educated in a particular field of study? Do they want to be somebody who has a family? Do they want to be somebody who devotes themselves to their spiritual relationships? And what are the services and supports that any individual needs to be able to accomplish those desires for themselves and their own lives? Minimally, at minimum, these plans should be developed every 3 years. However, it's very, very common that they're reevaluated every year, typically on somebody's birthday. That being said, any consumer can request to review their IPP at any time, and the regional center has 30 days of receiving that request to honor that review process and to take a look at what might need to be changed. And then you see here the very last bullet point, that notion of this being a person-centered plan, just going back to that and re-emphasizing the notion of individualized attention to meet persons' particular needs. Thank you. Next slide. And Yulahlia, feel free to jump back in whenever you're ready, if you're okay.
I think I'm okay.
All right, all right,
Thank
good,
you
good,
so
good.
much, Blaz. So we have 2 slides about categories of services. This is the one that's listed in the law. So there are a lot of potential services that the regional center can provide individuals. Community integration, employment and day programs, which are programs that can allow people to work with support or have a place to go during the day. Some folks refer to it as school, something that's done after they've graduated from traditional school, take classes, be with their friends, do art. So there's a lot of different options. Living arrangements could be support so that an individual can live with their family, or support so that they could live independently, or possibly live in a group setting like a group home. So these are all the different types of categories of services that the regional center can provide under the law. And then the next slide. The next slide are some of the more common services that we see regional centers provide. So for children, it would be respite, and that's where the regional center would pay another person to come in and care for the child so the family can get a break, so they can get a respite. You know, and they could do food shopping, or maybe the parent wants to go, you know, to visit, to go to church, or just to give them a little bit of a break, go to the movies. There's also a daycare reimbursement, depending on the child's age, that the regional center can provide the family if both parents are working or going to school during non-school hours. The regional center can also pay if parents want to attend a training or a conference. And then social recreation is something that the regional center can pay for, and that's what Blaz kind of referred to earlier, you know, gym memberships, music therapy, it can be, or music classes actually. So kind of social activities that folks can do out in the community and, you know, be a part of the community, swim lessons, horseback riding lessons, or horseback riding therapy. So it's pretty broad, and each regional center has their own rules surrounding it. But we like to let people know about this service because it was around, you know, over 10 years ago, and then went away, and now it's back. And a lot of marginalized families don't know about the service or don't know how to access it. So we just like to really talk about it because it can be such an important service for individuals. And then for adults, there are the day programs that I talked about, supported employment, and then the different living options that one can have as an adult. Supported living services that could be up to 24 hours a day of support. It could even be 2-to-1 support if somebody really needed it. Independent living is maybe someone who doesn't need someone every day to come into their home, but they could, you know, come in a few weeks to help them with shopping and meal prep and doctor's appointments. And then there are group homes. The independent living services, let me go back, can also happen if the individual is living in their family home. So maybe so the parents maybe don't have to take off work all the time to take someone to the doctor or, you know, to different appointments. And they also, under independent living, a staff could come in and just see what kind of fun things they can do together, depending on what their plan says. There's some crisis services as well, including placements. There's personal assistance services, and again, for adults can get respite and social recreation as well. And most of the services can be provided no matter what the person's immigration status is. There's some exceptions. So if somebody's working, you know, they probably have to provide their Social Security for that. I know some work programs try to be creative and, you know, maybe provide the person some gift cards or vouchers, but it depends on the program. But generally, everybody can get access to these services. So the regional centers they're called the payer of last resort. So this is why for minors, the regional center generally doesn't provide as many services as they do for adults, because for minors, the school is considered the generic resource, the resource that's supposed to be providing the majority of the services for school-age kids. And but for adults, you know, there is no requirement that the school provide services once they either graduate at 18 or at 22 after a transition program. And that's when the regional center provides a lot of the services. So some families can feel like what's the point of the regional center, you know, for my child, because we don't get that many services. And I just like to remind families that when the individual is an adult and doesn't have the school district required to provide services, that's when the regional center can provide, you know, day services or assistance with work, or maybe some staff to help the person take some college classes if they wanted to. So there's a lot of different options out there. And the regional center is the generic targeted case management provider, which means that they should be helping people access different resources, and, you know, letting them know about SSI benefits and IHSS. And then finally, the regional center can provide gap funding. So it can happen in different ways. I've seen this where a Medi-Cal, for some reason, Medi-Cal wanted to stop funding some nutritional, I call it milk, but supplement for an individual who needed it every day really to survive. And Medi-Cal cut the funding. The notice wasn't great, and the regional center agreed to provide the gap funding while we help deal with the Medi-Cal issues, because the family couldn't afford to pay, you know, $4,500 a month for this nutritional supplement that the child needed. And I've also seen regional center do it for when Medi-Cal is supposed to be providing ABA behavioral services to children with autism, and there are no providers in the area, or the wait list is, you know, 6 months or a year long, or they don't have Spanish speaking providers. The regional center can step in and provide that service if there's the generic resource, which would be Medi-Cal in that instance, wasn't available. So it's helpful. Before we kind of move on to complaints and appeal rights, do folks have any questions that they'd like us to answer? And we'll also take questions at the end. Okay.
All right.
Thank you, Blaz.
Yeah, thank you, Yulahlia. Yeah, so the second part of the presentation is going to sort of walk through, as I've mentioned already, a couple of dispute resolution options. Here, by the way, I don't know that we've mentioned it, but all of the citations in this presentation refer back to the Welfare and Institutions Code. So this is WIC section 4731 complaint. It's not the type of complaint that you would use if you were in a civil filing. There's sort of a complaint and then an appeal that we'll be talking about. But we'll spend just a few moments talking first about the complaint. And along the way, you've heard Yulahlia mention a variety of different rights that people have. The right to be assessed, the right to be informed of the results of that assessment within a certain amount of time. There are a number of deadlines that get triggered as you move through the process. And it could be that sometimes those rights are not upheld, and you need a way to sort of elevate the particular issue to someone who could, you know, help you overcome that. So the 4731 complaint is an administrative process through which you can enlist the individual regional center's executive director to try to investigate the matter and provide some proposed resolution. And if you're not satisfied with that proposed resolution, then you can escalate that to the director of the Department of Developmental Services. Again, there are a number of triggers that you can, deadline triggers that you can see on this slide. And there's a form. There's no real rhyme, or there is a form, but you could also just send an email that explains, you know, I had an IPP meeting where I requested an interpreter and one was not provided to me. Can you please investigate this matter? I requested services, you know, at an IPP meeting held 3 weeks ago. I have not received notice about the approval or disapproval of that request. Can you please investigate that matter? And they can be as simple as that, or they can be far more complex. I find, however, just a simple letter explaining, capturing the most salient, relevant pieces of the dispute and sending that to the local director is typically pretty effective at resolving the problems. You get just sort of like a higher level of review and attention drawn to your complaint. Now, this is exclusive to whether or not a right has been violated or whether or not any entitlement has been unreasonably withheld or denied. And that speaks to some of those violations of the timeframes that we're talking about, the unreasonable withholding. And so if you hear your clients grumbling about having to wait excessive periods of time for some other relief that they may need while they are going through their eviction or while they are dealing with their wage and hour complaint. Listening out for some of these issues may be a way to provide some supplemental support to your clients as they are dealing with all of the other things that life may have to throw at them. Let me have the next slide, please. Separate and apart from that administrative review process, there is a judicial review process, which was called the Fair Hearing process. It's the title of the team that I supervise, the Fair Hearing Project. And that is the title given to this, what is supposed to be relatively informal due process, procedural experience, but can oftentimes get a little bit complicated. It starts off with that written notice of action. Within 5 days of making a request to a regional center for any type of service, a consumer is entitled to written notice about that. Obviously, that connects back to our due process rights. You're dealing, even though with a nonprofit entity, they are acting on behalf of the state, and our due process rights are guaranteed there. Once you receive that notice, and I think we get into the details of that in the next slide, you have the opportunity to request this sort of progressive approach to resolving the issue, starting with an informal meeting, a mediation, which is a little bit more structured, and then lastly, a fair hearing. So we'll go through these bit by bit. Next slide, please. I'm going to start with the written notice of action. Statutorily, it must include each of the different items that you see listed here on your slide. It must include the decision, the notice of your hearing rights. It must include the reasoning and the statutory support that the agency is relying on in making its decision. So they actually have to cite to the section of the Lanterman Act that says we are relying on this citation for the purpose of saying, no, this is not a service that the regional center should be providing at this particular point in time. There are a number of rights that attach to this: access to information. You have the right to know what the decision-making process is and who is involved in those decisions, and to an adequate and timely hearing. And all of this is now wrapped up in a formal template notice of action that will drop in the chat here for you momentarily. It's now just part of a general move towards standardization that we have been, and many others have been, advocating for in this system for a number of years. So that's the notice of action. That notice of action will include a checkbox for each of the next 3 steps. They're entirely at the discretion of the consumer, whether or not they wish to seek an informal meeting, the mediation, or just jump straight into the hearing itself. The next slide talks about a couple of very important timelines. Somewhat akin to the notion of gap funding that Yulahlia mentioned earlier, there is, once an appeal is requested, what is known as aid paid pending, which is another way of extending access to services, this time not while the dispute is being resolved via another agency, but as it's being resolved internally. In order to protect that right to services pending the determination or the outcome of an appeal, you need to act within 30 days of receiving that notice of action. If it's an entirely new service, or if it's an eligibility complaint, a related denial of services, you actually have up to a full 60 days to file the appeal request. In those circumstances, obviously, there isn't a question about aid paid pending, but if you are already receiving a service that is being threatened with reduction or termination, then you must act within 30 days in order to get that going through the pendency of the hearing. Versus the 60 days if it's an entirely new requested service and they've never received it before. It's a sort of an effort to maintain status quo and to prevent as many unnecessary disruptions if possible. That's sort of the timing that needs to be considered there. Next slide, please. Okay, and then we get into the actual steps themselves. The first step, again, at the discretion of the consumer, is just a meeting. It's called in the Lanterman Act, WIC 4711 or 10, 4710, is an informal meeting, which is held just between the client and the local regional center team. The idea as at this point that they understand that there is a dispute, hopefully that they are paying a little bit more attention to it, given that somebody has exercised their rights to go to hearing at this point in time. It sends a more serious message that people should be paying attention to the problem and try to step in to try to, collectively resolve the issues. If and only if the client is represented by an attorney, then the regional center can also be represented by an attorney at this informal meeting. The idea here is, maintaining some semblance of a balance of power and not allow, this situation to be so lopsided that somebody wouldn't want to try to avail themselves of the process just for the sake of being intimidated or overpowered. The informal meeting, even though it is entirely discretionary, and some people, can feel as if it's just one more meeting, why go through it? I think one of the most valuable components of the informal meeting is because at this point they have 5 days to send yet another written decision, which oftentimes goes into much further detail than the information captured on the notice of action. So it can be just sort of like another way of unpeeling another layer and getting to the regional center's understanding. And so it can be, even though it's another meeting, it can still be very informative. And also, once the appeal is filed, the regional center has a very limited time, if I'm not mistaken, 10 days to organize this informal meeting. So it really does start quite an accelerated process, which can be very helpful, especially if it's a problem with a stagnated service, where there may not be an available service provider, or the authorization hasn't been processed accordingly. It can really be a way to accelerate that and get people through these really sometimes very difficult waiting periods. Next step, next slide, please. After that, there is an optional mediation. These are organized via the Office of Administrative Hearings. Again, those of you who are familiar with special education know the Office of Administrative Hearings. That is sort of the administrative forum that's used. They process hearings through hundreds and hundreds of different state and local agencies and municipalities. They're sort of a big catch-all. I think that for the legal aid community, we know them primarily for their special ed and regional center hearings. It's a mediation. It's convened and facilitated by a judge who is not participating in that role in that period of time. And it runs just as any other mediation. In my experience, they have all been via Zoom, but of course, if the consumer requests it, it can also be held in person, typically at the regional center office itself. And then lastly, next slide, please. If you are unsatisfied with the result of the informal meeting, and if the mediation doesn't resolve in a satisfactory settlement agreement, then you can push the matter all the way through to hearing. And as this slide suggests, that must be calendared unless a continuance is requested within 50 days. So it's quite an accelerated timeline, and that can be very, very advantageous for people who need to get these types of very critical supports that just help them, get by. Anything from being able to climb a flight of stairs to managing your behaviors to being able to overcome any other sorts of limitations in your life that would otherwise prevent you from thriving. There is an exchange. Discovery is quite limited, given that you only have 50 days. Discovery must be exchanged just a few days before the hearing. Again, that representation rule applies, which is really important. And that has to be disclosed just a couple of days before the hearing. And it just sort of runs like any other administrative hearing that any of you might be familiar with. On the record, the Lanterman Act explicitly calls for an informal type of hearing, although I think of concern to us, we have seen more and more judges utilizing legal terms of art, legal jargon, holding consumers to a more formalistic type of hearing experience that the individual, it may just have no familiarity with whatsoever. So it's just sort of important to make sure that even though we're expecting an informal process, that we're preparing our clients for perhaps something a little bit more structured. And that's the outcome of that. The vast majority, and you can find statistics on DDS's website to support this, the vast majority of complaints that are filed end up resolved in and around either immediately preceding or immediately following that informal meeting. Most cases do not make it all the way through to fair hearing. There are a number of cases that are unfortunately abandoned by people who don't, feel comfortable going all the way through, or maybe it's a strategic thought. They might reapply for the same thing later on once they have a greater sense of the need or a better sense of the evidence that they want to present at hearing. But it is anticipated to be a pretty good, and actually I think there's like I said, there's good evidence, good data that shows that people are getting their needs satisfied once they avail themselves of this dispute resolution process. So that's sort of the hopeful, optimistic message to encourage folks to consider, even if it's just checking that first box for an informal meeting, to really consider going through that process. And Disability Rights California is absolutely available. Both the Office of Clients' Rights Advocates and the Legal Advocacy Unit to help counsel people through these positions. If you want to ever consider referring a matter to us, we are definitely available. The next slide provides some resources that we make available. First, it's just our website. We have a fantastic publication called the RULA, the Rights Under the Lanterman Act, which is a plain language volume, sort of synthesizing and summarizing the entire Lanterman Act. It's not intended to be a technical read-through. It's intended to be a very practical document. We are constantly making updates to this as the law changes. And then a couple of other documents. You see that white paper that we published, I believe that was late 2023. The OAH website, where you can find all of the steps, all of the procedural rules, and all of the decisions that are published related to this. And then the 17 CCR code section there, which gets you a little bit further in depth on the ins and outs of the Lanterman Act. And our final slide is how you can contact us.
And it looks like we have some good questions. So I'll read them out. I tried to answer one, but I realized we need to read them out. So the first question in the Q&A, and I think there's also one in the chat, but the first question in the Q&A is, to request gap funding, what is needed? Should consumers contact their regional center service coordinators about the issue, or is there another process that must be followed? And would the service coordinator help the consumer navigate the issues to resolve it? So I answered that some regional center service coordinators and even supervisors aren't familiar with the gap funding rules. And I would suggest, making the request in writing if it's urgent, and if it's maybe a longer standing issue, to ask for the IPP and request gap funding at the IPP meeting. Also, if it's an urgent issue, there was a follow-up question about it. I would, probably also start with a phone call and maybe talk with a supervisor and then follow up in writing. And it could be to a director if it's very urgent, to request the gap funding for that issue. I'm going to pull out, I don't know if we're able to do that, but maybe we could put the Welfare and Institutions Code for gap funding in the Dropbox, because I've had to use that before, to let people know that it's there. And so if a regional center can only serve consumers who would otherwise meet the eligibility criteria, except the disability came after they turned 18, is there a different service system that those adults qualify for? I know generally, from my understanding, there's not kind of the same, wraparound that the regional center can provide. A lot of times it's, going to, it could be county mental health, IHSS, and home supported services, kind of getting similar services, but having to go through that process with each individual agency, Department of Rehabilitation. And Blaz, I don't know if you have any other thoughts.
Department of Rehabilitation, that's where you landed. Individuals own healthcare, right? Like their own medical insurance ought to be considered as well. There is also a waiver, it's beyond the scope of this presentation, called the Home and Community-Based Services Waiver, that is intended to provide additional services to individuals beyond what they might just be able to obtain via their medical insurance. So those are possibilities. And then I think just lastly, it's sort of mastering, not just learning, but really mastering through practice and iteration, the reasonable accommodation steps, and learning what that means for yourself and how to articulate how others can help serve you yourself. So I think those are sort of some of the alternatives. And another question from the Q&A, in the fair hearing process, is there funding or reimbursement for legal support through the process? Unfortunately, no, not that I'm aware of, Yulahlia. Although they may fund legal advocacy support for special education. It's actually quite a common service that ends up being funded. It's just kind of just sort of like a curious setup. So they don't want you to have legal support to challenge their own decisions, but they will provide you with funding to legal support to challenge others, other agencies. So just sort of how that works. People can come to DRC if they are seeking legal assistance. I think that the other children's legal rights advocacy organizations that we have in California are typically fairly knowledgeable about the regional center system, although they may not necessarily have funding. I'm not sure, I'm kind of speaking out of turn here. They may not all of us have funding to be able to do this work. It's quite rare, to be perfectly honest. The fact that this is a service that can fulfill the needs of someone who is undocumented, I think is partly what spurred on this conversation here today. And that's sort of what we're trying to answer as well.
And so I see regarding the client's attorney sending their position statements two days before the hearing, is it typically drafted and submitted without the knowledge of the regional center's position statement? Blaz, I don't know if you could speak better to this.
Yeah, I think the answer is yes, but going back to sort of what I emphasized about the informal meeting, you have that opportunity to sort of get their statement slightly in advance. You get some greater insight there. I would suggest, it's going to sound maybe a little weird though. Yes, as attorneys, we should be thinking about and preparing for the hearing. However, practically speaking, like I mentioned, all of the data shows that success comes around the informal meeting and around the mediation. And so, yeah, like you can like try to like figure out all of these things, but it's more of those soft skills and showing up and being supportive and helping to be a good advocate is what typically helps versus, you know, getting totally primed and ready and understanding the procedural ins and outs of the hearings in this space. There can be quite a lot of success in some of the preliminary steps.
Then I see, what sort of documentation can we provide the regional center if a family is denied ABA therapy? Would submitting a complaint move things along? And I'm assuming that you mean the regional center has denied the ABA therapy, and not the Medi-Cal. So with the regional center, I think it's showing why it's not available, if I'm understanding the question correctly. It's showing why ABA isn't available. You know, sometimes the ABA provider, you know, will let you know that there's a 6-month or 10 or a year waiting list, or we just don't provide ABA in that area. So it can be filing, you know, so it's kind of letting regional center know in the process if you have anything in writing. I've also encouraged families to file a complaint with their Medi-Cal HMO, who's supposed to be funding the ABA therapy, if that's where the therapy is coming from, to let them know that there's no ABA, you know, that's required to be provided by health insurance, that's not available. So I hope that answers your question. And what services does DRC offer to applicants and appellants? And does DRC have an income eligibility requirement? So we don't have income eligibility requirement for our services. And as far as what services do we offer to applicants and appellants, it depends. You know, my office, the Office of Clients' Rights and Advocacy, there's 2 people for 3 counties. So a lot of what we are able to provide is counsel and advice, sometimes technical assistance, sometimes direct representation. But it just kind of depends on our resources and the family's ability to, you know, knowledgeable about the process, the things that we look at to represent someone. The majority of families, though, who do have regional center hearings represent themselves. And that's why it's good that the law changed a few years ago that the regional center can't have an attorney present if the family doesn't have an attorney present. So I think that that's actually helped things overall in settling things before hearing. That's what I've seen. Blaz, I don't know if you have anything else to add.
And what do we offer? We offer a good deal of review and support. We are very active through a number of different parent groups that sort of, you know, coalesce around each of the regional centers just to help support through community legal education and training. I think both OCRA and the Legal Advocacy Unit have very robust community education training plans for the year. We also have our intake lines, which are available on your screen right now. If someone calls Monday, Tuesday, Thursday, or Friday from 9 to 3, they will talk to someone who is trained to listen to what's going on and has access and familiarity with the most frequent issues that appear, and they can provide some on-the-spot counsel and advice and some sort of general information. And then on a weekly basis, all of those intakes are handed over to our internal practice groups, filtered by issue area. And we have a team of attorneys that reviews each and every single one of those reports, sort of looking for any particular items that we are prioritizing, any egregious circumstances, or anything that fits any one of our other priorities or grant objectives. So that level of screening is something that we also offer to everyone that calls.
And I see the last question so far is, does DRC train partner with pro bonos to assist? I have with some of over the years, but it's been quite a few years, I have with some of the local legal services in our area, but it's been quite some time. I think we'd be open to it. The more people that can be trained in this area of law to help our clients, the better.
Yeah. There's no attorney's fees in this system, unfortunately, unlike what you see in special education. And so it really is going to depend on all of us as a community sort of coming together to issue spot and to refer some of these matters as they come along. So thank you all so very much for listening to this first presentation. We will have some colleagues on in a couple of weeks to share with you all some of the more in-depth advocacy that DRC is doing around regional centers, including some litigation and perhaps some policy advocacy work that we do in and around this space. Thank you so very much for joining us. Thank you to the Legal Aid Association of California for hosting us this afternoon. And if there are any questions, please don't hesitate to reach out. We're very happy to assist.
Thank you all.